Welcome. My name is Doug Lean. I'm the Manager for Economic Development for the City of Auburn, and welcome again, as I said, to another in our series of Business 101 classes. Today is going to be held and presented on the issues of insurance and human resources for your company. And we have a panel of experts here that are going to help you through the issues of general insurance needs, state-required L&I insurance for your employees, workman's comp, the legal side of how to protect yourself and who to go to when you do get in trouble, if that should happen. And then also we have an expert on human resources departments and the basics of how to set up those needs for your company, and again, how to properly handle your HR process in your company as you grow. Our first speaker today is going to be Brian Bernard. Brian is the local owner of his own insurance agency, Farmers Insurance, and is going to talk to us about general insurance requirements. Thank you. Brian?
Thank you, Doug. Again, my name is Brian Barrand. I've been a business owner here in Auburn for about 30 years. So if there's anything to know about insurance, I should know it by now. First of all, when we're talking about business insurance, it's a little bit confusing in the sense that most people are familiar with talking about their homeowner's insurance or their auto insurance, because everybody needs that. If you finance a car, you're required to carry, comprehensive and collision insurance on your vehicles. And so that's confusing enough. But when you get into the business arena, now you're talking about insuring your business and your liability and your property, your inventory. As your business grows, you want to make sure that your insurance program also grows with your business. So it's a really good idea to get hooked up with somebody that you can trust, that is familiar with the business community, and also that can give you some sage advice in regards to what you need now, but also what you might need going forward. So the first thing that most people think about is liability coverage. So what is basically liability coverage? This is a definition from the National Insurance Association of Insurance Commissioners, and basically it says liability, a certain or probable future sacrifice of economic benefits arising from present obligations of a particular entity to transfer assets or to provide services to another entities in the future as a result of past transactions or events. Three essential characteristics. A, it embodies a present duty or responsibility to one or more other entities that entails settlement by probable future transfer of use of assets at a specified or determinable date on occurrence of a specified event or on demand. B, the duty or responsibility obligates a particular entity, leaving in it little or no discretion to avoid the future sacrifice. And finally, C, the transaction or other event obligating the entity must already have happened. So most of us probably look at that and go, what did they just say? So John and his partner are probably the only ones that understand that, because they deal with that every day. So you and I, what does that really mean? I don't know. I'm not really that smart about it, but in simplistic terms, my definition of liability insurance, if there's anything that you're legally responsible for, either paying for somebody's bodily injury or paying for somebody's property damage, you have to be negligent. If you're negligent, then you're going to be liable. So if it's your fault, you're going to have to pay for it. That's my working definition of what liability coverage is. So in a business atmosphere, if you sell food at a restaurant and your product makes people sick, okay, that's a negligent act because your inventory, your supplies, your food product that came out of the kitchen caused people to get sick. So those people have legal recourse in coming back to you and saying, hey, I had to go in the hospital for 3 days and suffered X amount of dollars worth of financial loss because I couldn't go to work. I had pain and suffering because I was sick and throwing up and ill. So all of these things have to do with the liability coverage. So if you're a contractor, if you build something or repair something and it falls apart and it damages somebody's property or it injures somebody, there again, due to your negligence, you're going to be liable for those restitution payments for bodily injury and for property damage. So continuing on the liability, their premises operation, that's your typical storefront slip and fall. If somebody comes into your place of business and they are injured for any reason, they trip off of, something that's in the garage as far as a tool, or that's why most of your repair garages have, due to our insurance regulations, customers are not allowed in the service area. It truly is for their benefit and their protection, because they don't want you coming into their shop and hurting themselves, slipping on oil or so forth and so on. So a lot of times they just don't want you in there, because if you give them advice on how to fix their own car, they're going to charge you more. So premises operations, coverage for all sums up to the policy limits, which the insured shall become legally obligated to pay as the result of bodily injury or property damage caused by an occurrence and arising out of the ownership, maintenance, or use of premises and the operations of the insured in progress. And then products and completed operations coverage is another extension of liability, provides liability coverage for bodily injury and property damage arising out of products sold or distributed by the named insured or out of the operations performed for someone else after that operation has been completed. So if I'm a roof repair guy and I'm doing a really big supermarket and I'm not quite done yet, and so my guys are going to leave for the weekend because they're not going to work on Saturday and Sunday. So what they do is they put a bunch of tarps and stuff over the roof because it's not fixed yet. And I'm doing my due diligence by safeguarding all of the inventory in the grocery store and no damage to property. Well, over the weekend, there's a horrendous windstorm. All of the sheeting and everything that I put on the roof to protect everything inside the structure blows off, and the rain comes in. The water comes in. It damages all the inventory in the grocery store. Who's going to be responsible for that? I wasn't there. I wasn't on the premises at the time of that loss. But because I left my job site, I was the last one in control of that particular site. So my completed operations coverage is going to cover that event even though I wasn't there. So I can't be negligent because I wasn't there. That's the argument. Well, yeah, you can, because it was still your completed operation. You had completed it for the day. You hadn't signed off and got paid and then left. That would be more of a warranty situation if the roof leaked. And that insurance is not going to cover you for a warranty type of situation. So then we also have employees as additional insureds. So if you employ anybody in your business, whether you're a corporation, a limited liability partnership, or just a sole proprietor, every person that works for you is an extension of your business. Mary, I need you to go to the bank and make the bank deposit. Okay, she goes to the bank. If anything happens on that trip to the bank, you potentially could be liable for that. Let's say that she didn't have more than the minimum state requirements for her car insurance, and she gets into a negligent accident. It's her fault. She ran the stop sign. She ends up hurting 3 people in the intersection, and they come back and she files a claim, and that $25,000 or $50,000 of insurance from her car insurance carrier gets paid out. They're done. But there's thousands, if not more than hundreds of thousands of dollars of bills left unpaid. So they're going to ask Mary. I said, well, where do you work? Well, I work at ABC Company. I said, well, what were you doing at 1:30 in the afternoon? Well, I was going to the bank for my boss. Bingo. Now the people that got injured are going to file a claim against the business insurance owner, because the business owner is the one that sent Mary out to do the job. They sent her to go to the bank. So as an extension of the business, she was on a business appointment per se, and now she's going to be liable for anything that might happen. So it's kind of ironic when you see all the pizza delivery guys running around town. 99% of the insurance companies do not insure those people. And they may have a personal auto insurance policy, but if the insurance company knows that they're delivering pizzas at the time, there's a great chance that they're not going to be covered. So contractual liability, if you sign a contract with somebody and you don't fulfill the terms of that contract, you could be potentially liable for any financial damages or harms that come from not adhering to that contract. So as an extension of that, we do have contractual liability. Personal and advertising injury liability coverage will pay on behalf of the insured those claims which the insured becomes legally obligated as a result of any of the following offenses committed in the conduct of the named insured's business. Personal injury. Personal injury is false arrest, detention, or of imprisonment or malicious prosecution. We have libel, slander, defamation of character, violation of rights of privacy, wrongful entry or eviction, other invasion of right of privacy occupation. If you're a apartment building owner and you go into a tenant's apartment, it doesn't matter why. If you don't give the proper notice, 24, 48, 72-hour notice, that you're going to enter that premises, you theoretically could be negligent for violating this privacy standard. You're entering that residence without proper notification. You know, personal injury also would cover things like if you have a CPR card that you're trained to do CPR, and you're walking down the street and you see somebody that is in need of medical attention, and you have the card and you have the training, and you go, oh, I just can't do it. And you kind of just stand by and walk away. If people found out that you could have rendered assistance and addressed that medical issue, they could hold you negligent for malpractice because you did not practice what you were trained to do. It's almost like part of the Good Samaritan law where you're supposed to stop and help. And then some people go, well, what if I performed CPR on him and we were working on him for 15 minutes and then the paramed came and then they took over and they took him to the hospital and he died anyway. Well, 2 months later you could get a lawsuit filed against you for medical malpractice, just like you were a doctor, because whatever you did, you didn't do it right. So it's a double-edged sword in the sense that should I do it or should I not? But, you know, when you have that Good Samaritan hat on, more than likely, if you got the training, you should render the assistance. So most people won't even think about these other coverages as far as non-owned watercraft coverage. Basically, most policies are going to state that under 26 foot in length, coverage provided for bodily injury and property damage arising out of the use of a non-owned watercraft under 26 feet in length. What does that mean? It means if I have a Christmas party for my employees and I rent a 25-foot sailboat and we go out on Lake Union and we have it catered with beverages and food and somebody drinks too much and they fall overboard and they drown, I'm probably going to get served with a wrongful death lawsuit because it was my food, my drink, my boat, but I didn't own it. Otherwise, I'd have a boat policy, but I didn't own the boat, and there's a hold harmless agreement that I signed with the person that I rented it from, which means they're not responsible. They could come directly back to me and say, you're responsible for his death, and this policy will respond. Fire legal and tenants legal liability, it's another very overlooked coverage. It pays for the amount the insured is legally obligated to pay as a result of damages to the part of a non-owned building rented to or occupied by the named insured. It also pays if the insured negligently causes a fire in the rented or leased space, and the insured is legally obligated to pay for the damages. A real good example of fire legal liability is if you're in a strip mall and I'm leasing 800 square feet for my office, and I have a tendency to leave my coffee maker plugged in all the time. Well, let's say it's a $19 Black & Decker 10-year-old coffee maker and made in China, and it's made from inferior materials, and my staff forgets to turn it off, and then the pot dries, and overnight there's a fire that's caused in the building, and the fire investigators come and say, well, it started over here in the kitchenette area, and it looks like the wall outlet got overheated, and it started the fire. That's not a friendly fire. That's a hostile fire. That fire is my responsibility. So all of the damages to that section of the building that I do not own because I'm renting it could now become my legal responsibility to pay the owner for the repairs. So the owner of the strip mall, they might have the building insured. Their insurance company would pay for the repairs, but that insurance company then would have the right of subrogation to come after me because I was negligent because I left the coffee maker plugged in, and I could potentially have to pay for that. So if I have fire legal and tenants liability, I'm going to be covered for that. Again, the wording on most of these things is you need to have a trigger, okay? If you have a fire, that's a trigger. It's a sudden and accidental occurrence. It's going to basically make your policy respond. Without a trigger, there's probably nothing that you're going to be legally obligated to pay. So that's the basis here is if you're negligent in any way, pretty much your liability is going to be triggered and you're going to have to pay for that. Host liquor liability coverage for businesses and organizations held liable under a liquor law for the serving of alcohol, liquor at meetings or functions and not in the business of manufacturing, selling, or distributing alcoholic beverages. So if you have a restaurant in town, you're going to have a separate legal liquor liability policy. If you're not in the normal everyday business of serving alcohol, then this coverage is important to you. Because there again, let's say that I had an office party, John, holiday office party. I got lots of food and lots of beverages. I hired my own bartender. Somebody gets overserved, they go out and have a car accident and they kill somebody. They could come back to your business and say they were at your place eating and drinking. They left your place without anybody trying to stop them. So you were negligent in the sense that you weren't supervising your own party guests. So that coverage could be extremely important. Unlike homeowners policies, there's really not a host liquor liability clause in there. Most of your people that come to your house, and if they have a couple glasses of wine and they leave and they cause an accident, it's on them. But businesses are different. Because if you're in a business situation and your employees come over and their spouses come over and you're socializing and then you get into a situation where the boss is telling the employee or the employee's friend, come on, have another drink. No, I'm done. I'm driving. I'm good. No. So you have this authoritative figure telling you if you don't, there might be repercussions on Monday. So what do? You have to make a decision. Get fired or have another drink. Well, this host liquor liability will cover that. So now coming to the physical damage part of the policies, your business property. Business owners, special property coverage form, it basically means special form is the broadest property form available. It provides for direct physical damage to covered property subject to certain exclusions. So business property is anything that's going to be inside of your structure. So if I'm leasing an office, it means my furniture, my refrigerator, it's my wall units, it's my pictures on the wall. It's anything that I would have put into that building prior to me moving in. So the replacement cost is the value of covered property will be valued at replacement cost without deduction for depreciation if the limit of insurance on the loss or damaged property is 80% or more of the full replacement cost before the loss. So this is an incentive for you to have the correct amount of insurance. So if all of your contents inside of your business are worth $100,000, if you had to go to Home Depot and the furniture store and buy them new, then they want to make sure that you have at least $80,000 worth of coverage, because then the replacement cost endorsement is going to kick in and we're going to basically buy you everything brand new that you lost. But let's say that you only insure $50,000 worth of property and you have $100,000 worth of inventory. That's 50%. The replacement cost endorsement is going to get voided and you're going to be subject to a co-insurance penalty, which it's going to be what you did insure for, what you should have. It's going to give you a formula, a ratio, which in this case would be 50%. So instead of getting coverage for the $50,000 that you bought insurance for, you're going to get $25,000 of coverage. That's all you're going to get paid. So it's the insurance company's way of saying, please insure to the proper level to make your policy do what it's supposed to do. One of the other coverages we address on a daily basis is business income. It pays for the actual loss of business income you sustain due to the suspension of your operations during the period of restoration. The suspension must be caused by direct physical loss or damage to property at the described premises. The policy also provides extended business income, 30 days additional coverage after you have restored your operation. So if you have a direct physical loss, my building had a fire, and you cannot open for business, the business income provision in this policy will start paying for your electric bill, your rent, your employees' salaries, if they're key people, any of these expenses. The extended business income is 30 days after, because people, well, there was a fire at that building. They're not patronizing your business because they don't even know that you're open yet. But you can get additional coverage for advertising, hey, reopening, grand reopening after our fire, come see us. So they'll pay for those expenses. Machinery and equipment breakdown provides coverage up to the property limit, pays for direct damage to insured's machinery and equipment resulting from mechanical breakdown, electrical current or arcing or explosion of steam boilers. Also covers loss of business income resulting from equipment damage. Coverage is automatically included with the purchase of the Premier Endorsement Package. That's indicative of farmers. Extended the property coverage to include loss which results from the breakdown of mechanical, electrical, or pressure vessel equipment. And that equipment breakdown coverage can cover things like air conditioning. Let's say that you have a hotel and you have 196 rooms and the air conditioner breaks. Your people that are renting the rooms are not going to be very comfortable if it's 95 degrees out and they can't turn on the air conditioning. So if that air conditioning unit breaks down, your breakdown coverage would pay for the repair of the HVAC system. And a lot of people that have specialized manufacturing, let's say that you're making candy or you're making chocolate and you need these special gas burners with double walls and all this kind of stuff. And if something happens to a piece of your machinery and it explodes because there was too much pressure or something, you're not making any candy because your equipment just broke. So if you have the equipment breakdown coverage, it'll pay for that piece of machinery to be repaired as quickly as possible. And if there's any resulting business loss due to that, that would be covered. So what they talked about, you're closing your business because of a direct physical loss, that would be like fire or windstorm or tornado. But let's say that there was a loss at a big strip mall and the end unit was Macy's. Everybody came to that particular strip mall, that section of the mall, because Macy's was there. They were the anchor store. If you were in close proximity to Macy's and a lot of your business, it could be like a sandwich shop, was derived from the Macy's shoppers, and if Macy's had a fire but it didn't affect your business, that's an indirect loss to your business because your income might go down 70% because nobody's going to Macy's, nobody's going to the mall because there's a big fire. So sometimes you can pick up extra coverage for that indirect loss, but it's usually extra. So business auto coverages are another thing that is often overlooked. If you use businesses use your vehicles. I mean, you've got delivery trucks, you've got artisan contractors, roofers, electricians, plumbers. All of those vehicles, when you've got Chuck's Plumbing on the side and you have an accident, most people are going to think that you're rich because that's a company car. You have lots of insurance. It's a business, When in actuality, you could be just a little mom and pop repair shop that, fixes appliances, but they don't know that. So legal liability is bodily injury, sickness, or disease sustained by a person, including death caused by an accident resulting from the ownership, maintenance, or use of a covered automobile. Legal liability is property damage to any loss of use of any tangible property caused by an accident resulting from the ownership, maintenance, or use of a covered automobile. Exposures such as uninsured motorists and underinsured motorists, especially in Washington when 26% of the people don't have liability insurance that are on the road. So if you get hit by those people, you want to make sure that your business auto coverage has uninsured motorist coverage included. There's no reason not to have it. And then finally, to cover all of your exposures, we have a catch-all. It's an umbrella excess policy. An umbrella policy provides the added protection you need over and above your primary business liability policies. Coverage is afforded to protect you against being underinsured whenever a large general liability or commercial auto loss occurs. No one ever expects to encounter a loss that exceeds $1 million, but unfortunately in today's legal environment, losses above that size do happen. When they do, the added protection provided by the commercial umbrella policy gives you the peace of mind that you can have that extra protection you need to keep your business operating. Your policy not only provides indemnification for the actual damages, but it also pays for the defense expenses that often exceed the actual damages paid. So the rule of thumb when you're talking about a liability claim is if the insurance company is notified of an event that could potentially cause a loss, it might trigger the duty to defend clause. So if there's a legitimate claim, now the insurance company is on notice, and they have to say, wow, this guy had this loss happen. It's probably going to be covered under his policy. Now we have to defend him because we're defending our own checkbook because we're going to be writing the claim. So what happens when you have that duty to defend is the attorney's expenses are separate. Co-counsel with the insured and the insurance company's attorneys, those billable hours keep going and going and going. So the insurance companies could theoretically pay $1.5 million for legal expenses to pay a $50,000 claim if they chose to fight it. And one of the biggest examples is way back in the day when Bill Clinton was the governor of Arkansas. He had his personal insurance and umbrella were both a target of a claim for his misdoings with his employees at the time. When he was being sued for sexual harassment, his policies basically responded because they had a duty to defend because there was no exclusion for that kind of misconduct. And because of that willful act, and it's now illegal, most insurance companies have an exclusion on there for any type of activity like that because it's condoned as willful, purposeful, and illegal. So they don't cover that anymore. But the insurance company that he had paid $5 or $6 million in attorney's expenses just to defend $3 million worth of liability insurance. So you can see how that type of policy could be very, very important. That's it for me. Thank you, sir.
Thank you, Brian, and thank you for that information. Quick question for you, though. For a small business that's going through their due diligence to write their business plan and looking at the budgeting of what their overhead and operations costs are going to be, I'm sure your agency and other agencies will sit down with a small business and help them go through what they're going to do and the budgeting process so they know what to put in their operations costs.
Correct.
Good. Do we have any questions from the audience on insurance? Just a moment, she's going to have the microphone come over for you.
I'm a small business, and I would like to know, I have one vehicle under my personal home owner's insurance. Now, if I use my vehicle, my truck for my own business, am I better off putting my vehicle under that business insurance?
It really depends on the registration of the vehicle, because in most cases, if it's a personally registered vehicle and your legal entity of your business is a corporation or an S-corp, you want to have the vehicle re-registered to the business if you're going to use it for the business. And then it becomes part of the business asset. So anything that may happen with that vehicle is going to be covered under that commercial policy rather than your personal, because that's why you're a corporation or an LLC, is because you want to make that curtain. You want to divide your personal liability from your business liability. So if you own your vehicle personally, and I suppose there's a way of drawing up a lease document that says that ABC Corporation is leasing from, John Smith this 2015 Ford truck for, $450 a month for 24 months, that would be a legal contract, and then that personal vehicle would be covered under the business policy, so you could kind of get away with not having it registered into the business name. Because the biggest thing about commercial vehicles, and I get it, you've got to feed the ego. I mean, if I'm Harold's Plumbing downtown on Main Street, I want everybody to know that, oh, there goes Harold's Plumbing. But in actuality, if I'm having dinner at Oddfellows and I have a couple too many drinks and then I drive home with my family and I rear end somebody, when they get out of the car, they're going to see Harold's Plumbing. They're going to think that I'm, loaded. I mean, that's the public perception. And when the reality is I might not have any insurance or very little insurance. So you're becoming a target. So a lot of times what I suggest to some of my artisan contractors is go to the sign store, get a magnetic sign, put it on the side of your truck. When you're at work or when you're on a job site and you want to advertise your business, go crazy. Harold's Plumbing all day long. But in the instance where you're on a camping trip and you're pulling your trailer with your Harold's Plumbing truck, take the sign off the door. Now you're just Joe Schmo going on vacation. They don't have that connotation of being, enamored with wealth in the sense that you're a business owner. That would be my suggestion, but
Good.
it's hard not to feed the ego, though. I get it.
Thank you, Brian. Any other questions? Good. At this time, thank you, Brian. At this time, I'd like to introduce Aaron Hoffman. Aaron works for the state of Washington. The Washington State Labor and Industries Department is going to speak to us about workman's comp insurance. Thank you.
Thank you. I'd like to, what I've done here is I've taken a presentation that I give to my small business customers during outreach sessions. This is a 45-minute presentation, but I've narrowed it down to 20. I've stripped it down a bit. So I'm going to cover the things that Labor and Industries does. I know everybody's probably heard of it, but there could be a bit of a mystery about the things that we do, and I want to just cover those things. So for today's topic, here's an overview of Labor and Industries. Workplace safety and health issues, workers' comp insurance, prevailing wage, and wage and hour. So first thing is workplace safety and health. We have a Division of Occupational Safety and Health, or DOSH. This is a stock photo. You can see that it's kind of ingenious, actually, in a way. Not safe, but it's kind of ingenious nonetheless. So I'll go ahead and flip to the next slide for me. So what do? They do safety and health inspections. They can do this by complaints and referrals, which means someone can file a complaint, an employee can file a complaint, somebody from a union, say, can file a complaint about an unsafe workplace. And we do scheduled inspections, so an industry might get targeted. And we do follow-up inspections. So if they're out there and they find issues, they could show up again to make sure those are resolved. So first of all, why have a safe workplace? First of all, it's the law. All businesses with covered workers, and covered workers are all your employees and independent contractors who don't pass the independent contractor test, you have to have workers' comp. If you have, in that situation, you have to have an accident prevention program, a written one, that meets the safety issues at your business. And there's templates available online and there in your notes. And also, safety emphasis tells workers that you care. If you look, I'll go back to one real quick. There's that picture, if you see that there, that was actually sent to us by a business owner. He was out on the street, took a picture of that. It's about, 10, 12 feet off the ground. There's two ladders up and then people working at height doing, looks like painting work. So if we all expect our employees to do safe things, to use common sense, but they can do things like this. And if they should get hurt in this situation, they can file a claim, a valid workplace injury claim, and DOSH can also come out and give you a citation for actions of your employees. So again, why have a safe workplace? Because workplace injuries are very costly. Moderate claims can double your workers' comp rates. And if you're in the construction trades, your workers' comp rates can be very high. Just to give you an example, a brand new roofing business pays about $7 an hour per worker. And if those rates were to double in the third year, that makes you uncompetitive, $14 an hour. So moderate claim can double your workers' comp rates. Indirect costs are typically 1.2 to 4.5 times direct costs. What does that mean is that if you have $7,000 in direct and indirect claim costs, you'd have to get $97,000 in additional revenue at a 7% profit margin just to get that extra $7,000. So what is workers' compensation insurance exactly? It's a promise to injured workers. It gives medical care, wage compensation if medically unable to work after 3 days. And so this is what workers get if a worker is injured on the job, and that could include a worker running an errand, because auto accidents are actually a common workplace injury issue. And also it's a promise to employers. It's insurance, you don't pay the actual costs of the claim. And it's liability protection. An injured worker can't sue you for a workplace injury. So this is something called the great trade-off. Labor and Industries came about in 1911 as a direct result of the logging industry. Prior to 1911, if you were an employee and you were injured on the job, you had to sue your employer to get relief. The claim could stay open, or the suit could stay open for years before the worker got anything, if they got anything. Sometimes the business would just go out of business and the worker would be injured, untreated, employer would be out of business, and nobody would win. So what they did is in 1911, Business and Labor sat down, hammered out this agreement, and came up with workers' comp. So again, it's liability protection. An injured worker can't sue you for the workplace injury. So no fault, what does this mean, no fault insurance? Well, let me give you an example. So these are two photos that were taken by safety and health inspectors out in the field. If you look on the left picture, you'll see two guys working up on a roof, and you think, yeah, it's not too terribly safe, especially the one guy on the end of the roof there. But when you pan back, you can see just how high up they are off the ground. I'm not good at guesstimates like this, but what's that, 20 feet maybe? 25 feet? Again, if a worker fell off the roof, what would happen? Hopefully they would survive, at the very least survive, but there's a huge risk of death from doing this, or in serious bodily injury. If your workers got injured, they would be able to file a workers' comp claim, even if you told them not to do this. They couldn't sue you for the workplace injury, but again, if you were in the trades, in construction trades, it could double your workers' comp rates by that third year, and that could make you uncompetitive. So here's another one, another workplace safety and health photo that was taken in the field. So I'm not quite sure where this is at, but I'm guessing this may have been up in Seattle somewhere. If you see, there's a deep pit, backhoe dumping material into the pit, and on the left of the backhoe there, you see a worker in a white helmet. There's actually a second worker in that picture. Can you spot that worker? Kind of hard to see. You can see the white helmet. If you look at the foreground, middle, you can see a pylon, and then right behind that is the second worker. So there's actually two workers in that hole. Again, not safe, but again, if they were injured, they could file a workers' comp claim. The moral of the story is this: you have to make sure you hire the right people, have solid, accident prevention program, make it known that you don't put up with an unsafe workplace, because again, they get injured, they are covered. So who is covered by workers' comp? This causes quite a bit of confusion. I've spoken to, in about the 7 years or so that I've worked in the small business liaison office, my boss and I have talked to over 10,000, have 10,000 referrals, which probably represents about 9,500 plus businesses. And this causes a lot of confusion. Doesn't matter the sophistication level of the business owner, how many years they've been in business. We hear everybody in all industries misunderstand how this works. So who is covered by workers' comp? Your regular employees. Workers hired for labor only and under your direction and control. And what that is I have this on the back table we have the independent contractor guide. If the state presumes that everybody working for you is a covered worker. So it's in the law. There's a presumption that anybody you engage for labor is your covered worker unless they can pass the test that is in this booklet. There's two parts of the test. Part A says, are they bringing more than their personal labor? And what that is are they bringing big, heavy equipment to the job site? So if you're a construction company, if somebody is bringing a backhoe or a dump truck, that's big, heavy equipment, they're an independent contractor out of the chute if they own that piece of equipment. Or if somebody's bringing more than one of their own employees. So if you have a business, if you engage the labor of another business and they bring one of their own employees with them, they're an independent contractor. That's Part A. If they can't pass Part A, then they look at Part B, and there's 6 parts to Part B, 7 parts if you're in construction, and it's not an on-the-balance test like the IRS. They have to pass all parts of Part B, and all 7 parts of Part B if you're in the construction trades. One of the biggest problems about passing this test is direction and control. That's a very hard thing to get around. So I encourage everybody to look at the independent contractor guide. If you don't understand it, you can give us a call. We also have a brand new program called a predetermination unit, where if you're not sure, you call us, you can describe what you're doing, and we will give you a letter that says it passes or it doesn't pass, and you can use that letter that says it passes in a defense against an audit. So that's new, and I highly encourage you to use that if you have any questions at all. I just want to describe one quick story for you. This is the extreme example, but I want to just drive home the importance of this. When I first got to the Small Business Liaison Office, one of my most memorable referrals was a mom and pop business. They owned a heavy piece of equipment, and a friend came to them and said, "Hey, I want to learn how to run that piece of equipment. Once I learn, I will go off and do it by myself." And they said, "Sure, why not? You're not an employee. We never signed any paperwork, never shook hands, never agreed on a wage, never filled out any IRS paperwork." And the unfortunate thing is, they had this friend on their job site during business hours, and they were training him moving their regular customers' cargo. Well, unfortunately, this worker misused the equipment in some manner and tipped it over. He jumped out. The equipment landed on him, seriously injuring his leg. He had to be airlifted to the hospital, and he almost died in the process. Fortunately, he survived. The claim incurred, I think, about $130,000 in medical costs. Now, this worker had a choice. He could either pay the entire $130,000 himself, or he could let L&I pay for everything. When you come to that kind of situation, which one do you think the worker's going to pick? Pretty clear he's going to let L&I pay for everything. When the worker does that, L&I is going to say, "Who's the employer?" The business owner said, "We never hired him." We said, "It doesn't matter. He was furthering the interest of your business, therefore he's your covered worker." L&I has the ability to go after the employer. If you find you don't have a workers' comp account, we can send you through an audit, fines, penalties, and interest. We can go after the entire medical cost of the claim, up to, I think, 10 times the amount. And long story short, we went after this mom and pop business for about $120,000. Now, they could have gotten out of this by refiling their business license, checking the box stating they're hiring a worker, cost about $19, pay the premiums, which would have been about, I don't know, $20 or $30 for the time they hired him. So in all, they could have gotten out of this for about $50, but they never did that. They never told the state they had a covered worker. And because of that, they had to hire an attorney. I think, and again, it was a long-running issue, years and years in the making, and we held them liable for about $120,000, $130,000. Now, bear in mind, if you have friends or family that want to help at your business and they get hurt, they might have to make that decision as well. Do we let L&I pay for everything, or do I eat this whole cost myself? So be very careful about letting friends, family, and anybody, helping or volunteering at a for-profit business. So to continue on here, business owners are generally exempt from workers' comp. That includes sole proprietors, partners, corporate officers who qualify, and LLC member managers. Just to touch on this very briefly, L&I also does something called prevailing wage. Prevailing wages are required for public work, so if there's any amount of government money involved, doesn't matter if it's federal, state, or local, even if it's $1 of public money, it's a prevailing wage job. And wages are based on the classification of labor and location of work performed. Wages are determined by standard or prevailed wage in the county, and it's, again, a worker protection law. So if you're doing government work that involves government money, be aware that it could be prevailing wage work, and you'll have to pay the wage rates and file the right paperwork. So again, prevailing wage work is work, construction, repair, alteration, or improvement, and it has a cost to a public agency and includes maintenance done on contract as well. I'll touch on wage and hour rules just a bit. So minimum wage in this state is $9.47 per hour in 2015, $9.32 an hour in 2014. It changes annually and is driven by a 1998 voter initiative, and exemptions are rare. So most workers in this state are required to get minimum wage for all hours worked. There are some exemptions for outside sales and sleep or reside issues, but be aware also that Seattle and SeaTac have their own minimum wages, and it sounds like the city of Tacoma might be having their own minimum wage standards as well. So let's talk about, continue on for wage and hour rules, overtime. Most hourly workers are entitled to overtime. The exemptions exist for administrative, executive, professional, agricultural work, and it really depends on job duties. One of the most common things that I hear that is misunderstood for wage and hour is salaried worker. There was a well-known food type business that got in trouble with this because they said that all of our shift managers are salaried workers, therefore they're exempt from overtime. Well, it didn't pass the test laid out in the law, and they ended up having they lost a lawsuit over this issue. You can, a true salaried individual is somebody who does administrative, executive, and professional work. And there are tests in the law, there's state law, and then there's federal law, and you have to pass both parts of the test, and you go by whatever most favorable to the worker. So payment of wages, an employer must pay the agreed wage. So if you agree to pay a worker $20 an hour, you have to pay $20 an hour to the worker. If you don't, they can file a wage claim with L&I, and L&I can enforce that. You can change a worker's wage at any time, provided it still meets the minimum wage requirements, and it can't be retroactive. So for example, let's say you're paying somebody $20 an hour, and they walk into the job first part of the day and you say, hey, listen, times are hard, I'm going to knock your pay down to $15 an hour from here on out. You can do that. We highly recommend you make any changes in writing and that they sign that they have read and understood the policy. Again, it doesn't have to be in writing, but we highly recommend that it is. So if a worker can file a complaint with L&I if they don't get their agreed wage, and you can also make deductions from their paycheck, and that includes when you talk about shortage of till, theft, damage, etc., it's not okay except in the final paycheck. One of the things that I have to cover with my small business customers is typically they deal with a minimum wage employee, and the minimum wage employee will, short the till, steal from the business, etc. You can never drop a worker below minimum wage. So even if they tap your till, you can't reduce that from their paycheck if you're paying the minimum wage, because you cannot drop a worker below minimum wage for that type of issue. You can sue them in civil court and get a judgment there, but you cannot deduct it from their paycheck. And also depends on specific facts. We highly recommend that you call us first if you have a question about it. So again, I'm with the Small Business Liaison Office. The Small Business Liaison is Celia Nightingale, and I'm Aaron Hoffman. There's our 800 number and our email address. If you have any questions at all, there's actually more small business liaisons in the state, and we can get you in touch with them. So if you have a question about Department of Revenue, Department of Licensing, Employment Security, and a bunch of other state agencies, just get in touch with us and we can put you in touch. Thank you.
Aaron, thank you very much. That was very informative. Do we have any questions at all for Aaron on the state's portion of your world?
I've heard various stories about the L&I claim in the field that I'm in. Now, if a person's injured on the job, how many days or hours do they have to report that claim?
There's two types of injured worker claims in the state. Thank you. There's two types of injured worker claims in the state. One is a specific point in time where somebody slips, trips, falls, and let's say breaks their leg. The second type is something called an occupational disease, which is an injury that is built up more over a period of time, and a classic example is carpal tunnel syndrome. For a specific point in time injury, a person has a year to file a claim from the time of injury. For an occupational disease claim, I believe it's 3 years from the time a medical provider has told you that occupational disease was work-related.
Another question I have is on prevailing wage.
Yes.
Is bidding work determining? I noticed that in the area, Western Washington, there's diversity in prevailing wage of, for example, $50.
Yes.
North County would be 51.2, South County would be 50.05. How do I determine the tax with, in addition to the unemployment, the Medicare, or how do I deal with that?
Are you trying to determine which wage rates to use?
Well, I think it's confusing for a small business person when you're bidding on a job. You're dealing with the basic prevailing wage, but you're being, in addition to, you have to pay the LNI, you have to pay the Medicaid. Now, what is the percentage of tax should I be looking at on that?
That's a good question. I don't know. I don't know the answer to that one. Let me get your information afterwards, and I'll see if I can run that down for you, though.
Thanks.
Great.
I have a question. Can I ask a question?
Sure.
Okay.
Okay.
So let's say we have an L&I injury at our office. Someone files a claim and we get a citation. Where does the money go on the citation? Who gets that?
I know it's stated in the law, and I don't know where. I don't want to speculate on that, but I can find out for you. It's a very good question. I don't want to speculate. So.
Okay, Aaron, thank you very much. I think we'll move on. We're going to have a special presentation. We get 2 for 1 this next time around. John Stocks, who is a senior partner with Van Sicklen Stocks and Firkland Law Firm. Is that a new name that's been added to the firm, I think? And then also Victor Torres. They're going to speak to us about employment law, and as one of our top law firms in Auburn, hopefully they can help you figure out how to get in trouble or stay out of trouble. Thank you.
Thanks, Doug. Am I close enough? I'm John Stocks.
And I'm Victor Torres.
The reason there are 2 of us here is so I can give some tips and then Victor can correct me. And he's going to run the PowerPoint, hopefully. So a few disclaimers. As lawyers, we have to give disclaimers, and we'll probably put it in writing so there can be like credits at the end of a movie. But anything you hear or anything we say, you should double check because the law changes all the time. And you have to adjust to the law changes, even us as a law firm. Another disclaimer is you can listen to the news, you can do Google searches, but you should always check with an expert because even things I hear on the news, I believe until I double check it with Washington law. We are going to hit some buzzwords today, which are topics probably of their own, meaning if we say a buzzword like public accommodation or wrongful termination, it's probably an 8-hour seminar of that. So we're just going to open the door to a buzzword and then close the door on you. And we can't talk about personal confidential cases, and people always want to hear anecdotes, and we can't do that. Okay, our first slide. Now, I'm not a pessimist, but I'm a realist, and I think at our law firm, you have to assume that all actions will end up in court. And this, it's an analogy to monopoly because a business, you don't want to necessarily be a monopoly and violate antitrust laws, but you want to run your business, and monopoly is fun. And sometimes in monopoly you end up going to jail versus collecting your salary. And I want to address who you can sue, and if I've gone over the 3 minutes, we have a timer here. Basically, this timer here is is this for us? Like 3-minute warning? So we get warnings in court, and Victor and I, if we go over 3 minutes for our 8 slides, we have a warning to stop us from going past 3. Have I gone past 3? Okay, so who can sue you? Your employees, your customers, the government, your business partners, your neighboring businesses, your competitors, your ex-employees. The IRS can sue you. The city government can sue you. There could be nuisance claims. Even employees that you didn't hire can sue you for discrimination, not hiring them. So from a pessimistic standpoint or a realist standpoint, you just have to assume everything's going to end up in court. And that means you're not going to lose in court, but you undertake preventative measures to think about what if we end up in court. Even Microsoft gets sued, and they will win in court often because they prepared ahead of time. I have clients leave my office who come back a year later and say, you told me they couldn't sue me for this. What I actually say, because it's like a broken record, is, I told you when you left that they will lose, but everyone can still sue you, which means you're in court with attorney fees and expenses, even if you win.
All right, so this next slide, I'm going to talk about employment in Washington State. You probably already know this is sort of basic, but there is a presumption in Washington that employees are at will. What does that mean? That means that as the employer, you can hire and or fire employees for any or no reason at all, except for illegal reasons, which we'll go over. Now, there are a couple of exceptions to the at-will employment doctrine. One of them is employment documents or employer documents. And those things are such as employment applications, handbooks, policies, and those types of things. If you have documents, you want to make sure that you have quote-unquote at will somewhere noted in there. Even if you don't have those specific terms, you can use other terms that suggest that their employment is at will, such as you can be terminated, quote-unquote, at any time. That means at will. You can be terminated, quote-unquote, without cause. That means you don't have to give a reason. You can be terminated, quote, for any reason, unquote. So you want to make sure that you use some of these key terms if you have employment documents that you're sharing with your employees. There are some employers that provide some benefit or marketing situations where they will use the term, quote unquote, for good cause. So that means that you can only terminate your employee for a good cause. You have to give specific reasons in these documents, and most of the time it's because they've either stolen or did a crime or something like that. But you want to make sure that if you are allowing your employee to stay employed and only terminated for good cause, that you list those specific causes that you can terminate them for, so that everybody's clear. So again, there is a presumption that employment in Washington is at will. The other exception to the at will situation is if there is a contract. An employment contract, usually you spell out the terms of the employment and things such as length of time that they're going to be on the job, the rate of pay, and in employment contract situations, usually that employee can only be terminated, for example, if they do a crime. And so it provides a type of job security, both for the employer and the employee, because you have an employee for that specific length of time and you're going to pay them that specific rate for that amount of time. You want to be aware, be careful though, when you have a contract with an employee, if you don't follow those terms or you terminate that employee for a reason that's not spelled out in that contract, you become susceptible to a breach of contract lawsuit. So you just want to be careful with that.
Employment status. So you have W-2 employees and 1099 employees, and that's basically the end of the year form that goes out so people can pay taxes. And that status, and I think one member on our panel had this independent contractor guide. My view of that is we often have employers try to do independent contractors when they shouldn't. And if you assume that if the IRS is looking at you, or there's a lawsuit looking at you, or someone's trying to count your employees, there aren't really a lot of independent contractors in those lawsuits, because that's why they're in court. If the person owns their own car, their own phones, their own supplies, and they work off-site, and you have an agreement, then you can probably call them an independent contractor versus an employee and give them a 1099. We have a lot of 1099 employees at our law office, and it's someone like who will come in and fix the roof, or maybe does plumbing, or provides an expert service. They're not an employee. It's pretty obvious. But sometimes employers will think, aha, I see the benefits of calling someone an independent contractor. Maybe I don't have to provide insurance benefits, or I don't have to pay self-employment insurance or L&I. And those are things that you got to be careful about. And if a person's really an employee, then they're an employee, and you shouldn't try to usurp the law on that, because you'll lose. Blah, blah, blah. You can get this on Amazon for $4.99.
So let me talk a little bit about common law in Washington. As you heard from Aaron, an employee can't really sue the employer for injuries, because there are situations where if you're injured on the job, you can seek L&I coverage. In this situation, under the common law, if a third party is injured as a result of your hiring an employee, and that hiring was negligent, or your retention of that employee was negligent, you can be sued by that third party. And so one of the situations was, for example, actually, there's a case in Washington where is a security company, and they employed an usher for a concert. And so this usher was showing people to their seats, etc. On this particular occasion, this employee showed a 16-year-old not to her seat, but to another place where he proceeded to rape her, essentially. That company was sued, and of course, they were found negligent and had to pay a lot of money. Under that particular situation, what they should have done is done a background check. Under Washington law, both of these particular claims, negligent hiring and negligent retention, those can be sustained against you if there is an employee who is incompetent or unfit, and you know or should have known of that particular unfitness. Now, what does that mean? If there is, in Washington, there's what's called a special duty of investigation. If the line of work puts an employee in a position of responsibility, such as security or the usher, where somebody from the public is relying on that particular person, you must conduct a background check. It also arises if on an employment application where there's no responsibility whatsoever, if on a application you see inconsistencies that you should raise alarms in your mind that there's something suspicious going on, you should conduct further investigation into this person. If you hire this person and a reasonable person would have found these inconsistencies suspicious and you didn't follow up on those, you could be found liable. So there's a stat up there that, according to the Workplace Violence Institute, negligent hiring costs U.S. businesses more than $18 billion annually. So the graphic in the lower right-hand corner is you want to watch out for these seedy and suspicious characters. So just be careful with who you are employing.
Okay, handbook and policy. So maybe you've heard a few things already, and I have trouble as an employer of 23 years, and I used to be a firm of 3. It was my partner, Mr. Van Sicklin, and myself, and one assistant. And so I miss those days for a lot of reasons, because small can be good, but most businesses want to grow, and you start hiring employees, and you start getting more official, and you start crossing thresholds like 8 employees may invoke state law, and 15, is it 15 still on federal law? 15. So you have to have 15 employees for someone to say you violated the Americans with Disabilities Act or something under Washington law, the Washington law against discrimination. Those are just a few examples. But I always say darned if you do, darned if you don't on a handbook or policies, because you want to put things in writing. But case law in Washington over the years, and sometimes looking under the federal court cases, those can be binding, even if, as Victor said, you're at will, you can be fired at will, you can quit at will, there doesn't have to be a reason. You still might write something in that contract that you perform under that creates a breach of contract. And so sometimes you think, well, I just won't have any written policies then, because then they can't sue me under this contract. Well, then you might have expectation problems with an employee who doesn't, what are the rules, what can I do? And they might sue for overtime wages or not appropriate breaks, things that you should have spelt out. So what's the answer? Well, at my office we have a rules book, which is just rules about our office. It's not a handbook. That word had a buzz in the case law for a while, that an employee handbook. Danny's got sued for an employee handbook situation. And they said, no, it says at will, it says at will. But in that handbook, there were other policies that basically the employee was allowed to sue from. I think you mentioned the rules apply. You have to enforce the rules or you can be in trouble. We had an employee, hypothetically, we had an employee years ago who, we can't talk about people, so we say hypothetically. There was an employee who worked overtime and we didn't approve it. So we have a rule. You can't work overtime unless you get pre-approval, and we'll often pre-approve it. But here we are looking at the laws and the statutes and the wage, what is it, minimum, the minimum, there's an initial for it.
The Minimum Wage Act?
Yeah, Minimum Wage Act, MWA, where, we're reading this, and so we tell this employee, you can't work overtime, but she still did. He or she still did. And we actually got to the point where case law told us we had to discipline that employee. There's this hardworking employee who's staying there till 6 or 7 at night getting her work done. And we're like, well, we either, what we mostly did is we just end up paying time and a half for that. Because we didn't want to face an MWA. But there were times where we said, you worked past your time, you worked through your lunch, you can't do that. You need to take your breaks, and we'll discipline you if you don't. Sounds kind of harsh, but you're really protecting yourself. And hopefully you're making a better employee because they need lunches and they need not to work late at night sometimes, unless there's a major project and you agree to pay them overtime. Did you mention if you have rules in your handbook or in your policies and you don't follow those rules? Yeah, we covered that. So we covered that. You got to make sure you follow your rules. A lot of people have this fantastic written policy book of 20 pages and then they just put it in the back, in the back closet or somewhere, and don't follow it.
Well, I think one of the situations that we were kind of talking about, and maybe I don't think we mentioned it here, but internally in our office, we're talking about if you have a rule of progressive discipline, for example, you want to make sure that you follow that, because if you don't and you just simply terminate that employee can come back and say, well, here's the handbook you gave me. It has progressive discipline that is spelled out by you. I should have gotten a written warning or an oral warning first before being fired. And then they can sue you, and then you would be liable because you have that policy that you failed to follow by yourself. So that's one example. So WLAD, for those of you that don't know, that stands for the Washington Law Against Discrimination. This is a law that you should know and know very well. This is one of the exceptions to the rule of an employer or an employee can't sue their employer. This is one of those unlawful things that employers cannot do. So if an employer discriminates against an employee or retaliates, they can be sued. And let's talk about that just a little bit. In the statutes, there is what's called RCW 4960. That stands for the Revised Code of Washington, Chapter 49, subsection 60. You should probably take a look at that, and it spells out pretty well what you can and can't do as far as what's discriminatory. It covers things such as race, creed, color, national origin, sex, military status, sexual orientation, disability, religion, age, and other protected classes. Each of those categories is an 8-hour seminar in and of itself. So I'm just opening the door, unfortunately, but those are things that you should probably look into pretty well. Just under the category of sex, for example, that includes, it's a broad category, it's a broad definition, it includes things as gender, it also includes pregnancy, and one of the most current issues was breastfeeding at the workplace. I mean, those are all things that are protected and that you can't disallow or retaliate against a person for doing. Under the military status, there is a federal law that is called USERRA, and that stands for the Uniformed Services Employment and Reemployment Act. That's a federal statute in and of itself that's also very involved, but it does protect active military service, as well as National Guard and others. Disability There's a federal law called the ADA, Americans with Disability Act. Disability, surprisingly, is a very broad definition as well, and that includes sensory, mental, and physical disabilities. I actually had a case hypothetically, where this person had, I think it was called seasonal disorder syndrome.
Seasonal adjustment disorder.
It had something to do with seasons.
See, he knows
Yeah.
all the acronyms.
Yeah. So in any event, this person had a situation where she changed somehow during the winter months. And the employer didn't accommodate her needing brighter lights in her workstation or anything like that. The employer just kind of blew her off and said, just make the most of it. That employer had to pay, unfortunately. So anyway, these are broad definitions, broad categories, so you just want to make sure that you're familiar with it. This falls under the category of civil rights, and the state of Washington, as well as federal law, is very protective of civil rights. And so as an incentive for employers to make sure that you protect civil rights under the WLAD as well as federal law, if the employer is found liable for violating civil rights, the EEOC and/or the Human Rights Commission can get involved, conduct an investigation on the employee's behalf. And if you're found liable in a lawsuit, you can also be liable for that employee's attorney's fees. So there's a lot of incentive there for employers to kind of do the right thing. So you want to make sure that you are.
See, we drew slides, and this one's scary for me because we have an expert at the end of the table. But let me pretend I'm an expert because I went to the University of Washington and had a business administration degree in 1980-something. And there was a class about HR.
1980.
Yes, 1980-something. Anyway, so is that a picture of you a couple of years ago? Or
No.
No, okay, that's your brother. So this is a tough scenario for me because as a young lawyer, I was a performer. And then I became a leader, theoretically, and then I became a manager, and then I was HR, and I was personnel issues and hiring and firing. The most important thing I can tell you about this subject is sometimes consider an outside resource, even free ones, that help you with hiring and firing because, there are lots of mistakes in hiring and firing. You heard about negligent hiring. You hired the wrong person. Well, you should have hired an outside source to do a background check for $50. You can send a thing to Washington State Patrol to get a criminal background history for, I think, $35. You can also find mentors or people who might be willing to say, hey, I'll help you do your first few interviews so you can see how it's actually done. But for me, when major HR issues come up, I'm not qualified to do it in my business. And so I will look outside. And lawyers have a lot of referral sources or someone who will come down or even bring in, an outside investigator to deal with, for example, two employees that they have an HR issue and a personnel issue, and they come to you expecting you to side with one of them. You just can't do that if you have too many employees because it'll look like favoritism. It could be a lawsuit because the person who felt they were not receiving favoritism is a protected person by class or race, religion, or sexual orientation. So I've noticed that I've been able to find a lot of free stuff, and it's a relief to and sometimes we pay for these outside experts, but it's a relief to give the problem to someone else and let them try to solve it where you can go back to performing. So I think when you're small, if you're a one-person operation, well, your only personnel issues are with yourself, so you can argue with yourself and deal with those problems and probably not get sued. But as soon as you get an employee, you're going to have HR and personnel issues. I think in every firm, every business you're going to wear the hat of, and Brian might sort of be this way because I know you're at 4 employees or 3 or 2. 2. So I know he's a leader, an entrepreneur, a manager. He hires and fires. He has to do legal issues, taxes, bookkeeping, advertising, even logos. Starbucks sued a company in New Hampshire for using Charbucks roast, and this is mom and pop shop in New Jersey or somewhere where they roast the dark coffee beans and called it Charbucks, and Starbucks sued them. They lost. I'm pretty happy that Starbucks lost. Did anyone see on the news that Starbucks is getting sued again? A cop in some other state got coffee spilt on his special area, and his wife said, quote, well, she said something, quote, she's suing because the sexual parts aren't as good, which is, you know, if you're going to be McDonald's, and we've heard about the McDonald's coffee cup cases, but anything in your business could cause an injury to someone. I got way off the personnel issue subject, but.
You're done, right? Okay. So the last slide that we have before we get to the questions is emerging issues. These are sort of current things that have been in the news with employers. Facebook doing, sometimes you want to do background checks and you want to search the internet and look at people's social media. So long as they are made public, you are free to peruse. If they are made private, you can't ask the potential employee, hey, can I get your Facebook login, or can you show it to me? It could be seen as cyberbullying, so you want to be careful. The arbitration clauses in handbooks and/or contracts, that's been a big issue because it saves employers the heartache. If there is a conflict of having to go to court, you can have it done privately within an arbitration. Employees don't like it, however, because they want the ability to go tell their story in front of a jury and make it public. The question is whether or not the arbitration clauses in those documents are enforceable. They can be enforceable if you provide those things up front and inform the employee at the time of hiring that they are subject to this. If you hire them and then you say, oh, hey, by the way, here's a handbook and you're subject to an arbitration clause, it may not be enforceable because it's subject to contract analysis, which means there has to be an offer and acceptance as well as consideration. So if you told the employee about the arbitration clauses at the time of hiring, the consideration would be the promise of a new job. If you've already hired them and you've said, hey, here's your handbook, you're also subject to arbitration clause, you have to give them something new. You have to give them added money. You have to give them some sort of other benefit to make it enforceable. So you want to be careful if you're going to consider that. The last thing that we have is domestic violence. A lot of employers don't know, even the bigger ones, that Washington has a Domestic Violence Leave Act, the DVLA. That allows, and that's RCW 4976. The legislature passed that in 2008. It allows victims as well as family members of domestic violence, sexual assault, or stalking to take reasonable leave to take care of legal, law enforcement, or health care needs. I actually, hypothetically, I was involved in a case where a larger national company failed to realize that in Washington we had this DVLA. They actually terminated an employee who had to take care of business because of a DV situation. We sued, and the employer had to pay not only the damages for terminating that employee, but for the attorney's fees because it's a part of the civil rights. So you want to make sure that you are aware that if an employee is subject to DV, that you take precautions and do the right thing.
Sort of a concluding point, open a business, it's exhilarating, it's positive. We sound a little negative because we have a checklist of things in our head swirling around because we've dealt with so many employers who've screwed up, including, perhaps even us sometimes where we need to change something. But don't take it all as negative. Have a checklist where you can look at all these acronyms, RCW, FLSA, DVL, PAO, RCW, blah, and you can kind of go through that checklist. You don't want to learn from experience. You don't want to have to get sued and go, oh, now I understand what this policy is. So, questions?
I think that's his job.
Oh, Please sit down again.
Actually, I'd like to make one clarification because John and Victor and myself, we've all used the term independent contractor. And just for the record, I want to be very, very clear that these are the ones that I can think of, these standards. The IRS has their standard of independent contractor, federal taxes. For wage and hour, minimum wage and overtime, has its own standard for independent contractor. Workers' comp has its own standard for independent contractor. Unemployment insurance has its own standard. Safety and health has its own standard, and I think prevailing wage has its own standard. They're all different. The toughest one to pass is workers' comp. Just because somebody passes the IRS test does not mean they pass any others. So just be conscious of this, that if you hire an employee, you're at least going to touch the IRS, minimum wage and overtime, workers' comp, unemployment insurance, and safety and health. So just be very conscious of that. A number of times, I'll talk to a small business customer that said, the IRS said they were an independent contractor, therefore federal law trumps state law, doesn't it? And I have to tell them, IRS is for federal tax purposes. We're workers' comp, different systems, different laws, and it comes as a shock. So just want to be very clear right out of the chute that you have to be conscious that there are different laws and different standards concerning independent contractor versus employee.
Any questions from the audience right now? Okay.
I've been in construction for over 25, 26 years. I'm here to tell you that when you go back to, you talk about the legalities of workers' rights, you know, I have to say, it's hard for me to take it serious these days because I have been on the end on federal projects where I went through those procedures of getting the legal advice, you know, and what are my rights, you know, and being fired just for no reason. And I think it all comes down to policing these agencies better. We need to find a different way of doing it because I'm going to tell you for a fact, discrimination is live and well in Washington State, regardless of what the laws claim to do.
So I had a question about the Human Rights Commission.
I want to answer her question. She didn't ask a question, but I agree with you, and I think that's, for lawyers, we tell people to go to your legislature and try to beef up the laws. I think policing agencies exist, but lawyers always have a tough time because we look at clients and go, well, that's what the law says. I can't change it, even though we'll try. But
It's surprising how King 5 could get to the core of the bottom of things and how they're moving things around. And we could go back to some other agencies on that. But anyway, I just don't.
yeah, we like the news. We'll send them press conferences anonymously.
So here's one more thing to as an employer, even if you're as an employee too, is that I'd mentioned the workers' comp. It's a right in this state to a worker. And I've run into the situation a couple times where an employer says, yeah, I offered to, my worker was hurt on the job and I offered to pay for their medical care out of pocket. And I said, don't do that. That's illegal. If somebody's injured on the job, by law, it has to go through workers' comp. If an employer pays for it or attempts to pay for it, that could be construed as claim suppression, which would be a violation of a worker right. And we have investigators that can investigate an employer over that issue. So just, again, that's something to be aware of. And in fact, if an insurance company, from what I'm told, if they find out that this should have been a workers' comp claim, they'll just deny the claim anyway and say, file it through your workers' comp system.
I had a question about the Washington Human Rights Commission. I understand that religious institutions are exempt, and maybe there's other organizations that are exempt from that. Personally, I had a situation happen. Anyway, why is that?
That's a good question. It was actually just recently litigated at the Supreme Court. And there are very specific, even though a religious institution is exempt, there are very specific guidelines for which they have to follow. Otherwise, they will fall into the general employer category. And I'm not really familiar with all of the specific guidelines, but I know that case is out there. It's recently published.
So I'll answer with a question. Can a judge or pastor refuse to do a same-sex marriage and avoid getting sued? Anybody? I'm supposed to know the answer. Yeah, you can always be sued. There are cases where, on the news, where people refuse to perform weddings or provide flowers to same-sex weddings and, any other protected class. But judges and pastors, I read somewhere today about, in preparing for today, they can be sued for not doing certain things, even if it's against their religious beliefs of their own. To be continued.
Hear these stories, but now I'm becoming the employer, and now the shoe is on the other foot now, beginning to be on the other foot. And my biggest concern is I can see it on both sides now. Where are my rights? If I would think, what my right is, I don't want to hire this person because they're whatever their faith is or whatever, then that should be my right. But on the other hand, being an employee looking for a job, well, if I'm going to go eat at this restaurant, I don't like, I go to go to another restaurant, but sometimes we are forced. Sometimes people are forcing, and I think that's where we're having the issues right now, is that where do we have personal rights versus the law's rights? I mean, where are our rights at? It's a gray area at this point.
All right, thank you. Sarah Bowles is the Director of Human Resources for Orion Industries here in Auburn. They employ well over 300 people. She's been a professional and expert in this field for a long time, and we've asked her to do two things. One, as a small business startup, what are the basics that you really need to do as a small employer to keep yourself organized, and what should you do? And then as you move into being a larger employer, how should you grow that professional department within your company to serve the needs of that operation of the company? So Sarah, thank you.
Thank you. So we've talked a little bit about HR and HR responsibilities, kind of a couple of different aspects of it, but one of the things I always want to think about is a lot of us have a tendency to see HR as a department. And HR is not a department. It's part of all of our responsibilities as an employer, as a leader in our organizations. And for small organizations, there may not be the need for that. The Society for Human Resource Management says that once you have about 15 employees, that's about the time to start thinking about having an HR representative. Now, that person may not have HR be their primary function and their only function. And I had that as my own personal experience as my first HR role, was that HR was part of what I did, but it wasn't all of what I did. And I had other areas of responsibility in my duties. We have about 300 employees within our organization, and including myself, we're a team of 4. And so as you grow, it becomes something that you want to think about. But we do expect all of our leaders within our organization, even though we do have that HR department, to be thinking of those the HR mindset, because all employees are entitled to a safe workplace that is free from discrimination and harassment. And that's something that we all have to remember, that is our responsibility. When we talk about our policies, one of the things that we need to be sure is that our policies are being consistent and that we want to enforce them. Sometimes we can write a policy about what we hope to be and things that we wish to be able to hold ourselves to, but it may not be realistic or it may not be legal. So one of my examples is when we talk about email use. So you provide a company email address to your employee. You expect them to use that for business purposes. Some agencies have opinions on these types of things, and you think it should be your right to be able to tell your employee how they should use their email address, that you need to use it for a business purpose, but that can actually be illegal. So by having a policy that says employees are not allowed to use email, company-provided email, for non-work related communications can be viewed as illegal. So what you want to think about is having an email policy that talks about limiting excessive use for non-personal or for personal items, and that it's something that doesn't necessarily interfere with your company business. So it may be something like large files or video. It may slow down your system and make it difficult for the system to maintain productivity. So we've heard from a lot of experts here today about different aspects of the law, and as you can see, we've had some questions, and we don't have all the answers. And as a business owner and as a leader in your organization, you're not expected to have all the answers. So develop relationships with individuals who can help provide those supports. You're not expected to know everything, and best practices can change. Laws change over time. There is constant change. A couple of years ago, you could have told an employee that they can only use email for business purposes only, and now that's not the case. Some resources that you might consider is the Society of Human Resources Management, SHRM. It is available to everyone. There's a membership fee. It's about $180 a year, and they can provide some really great resources for you. So there was a legal update that came out yesterday afternoon talking about some things that they're seeing coming through the pipeline, their opinions on those types of things. They're also great when you're looking to write a new policy or you need a form. Why reinvent the wheel when you can go to somebody else who has a little more knowledge and you can use that as a starting point and see, does that meet your needs and is that appropriate? Also, networking with others in your industry. They probably face some of the same challenges, and you can talk about what are your practices, what are their practices, what are some of the struggles that they're having, and work together to come up with some of those solutions. Memberships in organizations such as Archbright, which was former Washington Employers, they provide some HR guidance and support, and they also have HR contractors that can come and partner with you as you're looking at different types of things. We talked about an employee handbook and some of those challenges that you can fall into, and they will review your handbook and work with you to how to correct some of those challenges. And a lot of those things that they offer are free with your membership. So sometimes it pays to spend a little bit of money. My final suggestion is to build a relationship with an employment law attorney. When you're making some of those changes, in whether it be your handbook, your policies, or you're looking to maybe separate with an employee or hire somebody new, and you just kind of want to run through it with an expert of what are the risks you face if you make this decision, that can be a great call that you made and well-spent dollars. And it may seem like you want to save that money by not making that phone call and paying that hourly rate, but if it can keep you out of litigation or having some ideas of what are the risks you face by making the decision and you're making an educated decision, it can pay off. Records retention. Part of being an employer is keeping records. And we moved into our brand new building here a few blocks down the street. And when we moved in, we had this gigantic mezzanine that was full of all of our records, and it was kept under lock and key. We had all of this space to do this. And we thought we were going to be this paperless organization and we weren't going to need any space for records. Well, that was really funny because I have to keep employment applications for a year. Where am I going to keep them? I have to keep personnel records 7 years past separation. So if you have a large employee base and you have, even a 5%, 10% turnover every year, you have some files you have to keep for a while. And then your payroll records, you need to keep them for a minimum of 4 years. So quickly, we had to find a place to store these records. And we did find that space, and we have to manage it very tightly to be sure that we can make all of these record retentions. Now, some may advise you to keep some of these records longer, but these are the minimum record retention that you have to keep. So I want to take some time to talk about hiring, because this can be the hardest aspect of it when you are getting ready to hire. So when we're looking at a candidate, this may seem obvious, but what is that candidate going to actually do when they're in this role? What do we want them to do? Or do we have an idea of what we would like them to do, but it's not really matched to what their job is actually going to look like on a day-to-day basis? Something else to consider is, how are you going to find this candidate? Are you going to refer from current staff? We find about 30% of our new staff come from referrals of current staff. And it's not because they get this huge incentive to do it. They think we're a great place to work and they want their friends and family to come and work with us. And it's not just a company that I work for now. I find it time and time again. That is where you're going to get a lot of referrals, is from your current staff. Are you going to work with a staffing agency? You want to outsource that aspect of it, let them do it. How involved do you want to be in that process? Or are you going to do it completely on your own internally and start with things like posting an ad? We do all of our hiring internally, and we've spent a lot of time in our hiring process. And it definitely pays off when we're looking to make that hire by that investment that we've put into that time. So when we post our ad, we're going to look at what type of position we're looking for. It may just go on our website, and we may get enough traffic that way. We may look at a couple of different ways and avenues to do that. When we're looking at our process, our biggest piece that we look at is culture and our culture fit. Every organization has a culture, whether you want to acknowledge your culture or not. It could be a great culture. There could be areas for improvement, and knowing what that culture looks like and what you're looking for. So we ask a lot of open-ended questions and really look for a conversational dialogue in that very first part of the interview when we're talking about culture and what someone is looking for in their next position and their next organization to be sure we have a good fit. So one of the questions we ask is, can you tell me about a time that you had a difference of opinion with a coworker or supervisor? It's a good leading question about someone talking about what an experience they had, and then you can have a conversation about it and see if you're a good match. Do you think that individual will work well within your culture of your organization? The process has to be consistent with all applicants, and an example of that is reference checks. So maybe you know someone or have heard something about someone, and you want to start looking at their references before you've finished the hiring process. But your protocol is you don't check references till after an employment offer is made. So if that's your practice and your protocol, you need to be sure you're being consistent. So if you have a pool of 3 candidates that are in their final stages and you're wanting to check references before you make a final decision, you need to be sure that you check references with all of them. It can cost a lot of money if you make a wrong hire. We've heard some examples, whether it be an L&I accident or some of those other aspects of it, but even just down to just making a poor hiring decision. Hiring can be a really lengthy process, and it can be really easy to say, I'm not finding exactly what I'm looking for, and this person it's close enough. I can work with this, so I'm just going to make this decision because I just need somebody here today, and if I keep looking, it might take another 2 to 3 weeks to find that perfect fit. This can be really dangerous. One, there's the culture aspect, and they may not fit. They may not be happy. They may make others unhappy because of that culture change, and they may choose to leave in a really short period of time. And that may be okay, but you also need to think about how much time and money did it cost for that hire and bringing that person on. So we're not talking about just the recruiting cost, whether it be that ad post. That's something that we've seen as really tangible. I posted an ad on this website, and it cost me $150 to post that ad. It's also their wages while they're with you, and it's also that training time. So if you have someone who is providing them training and they're not able to do their tasks, it's their wages that is also going into that training time. So my biggest piece of advice when you're looking to hire is don't hire out of desperation. Hire because you have a good fit, you have both skill set, culture, and you think it's a great addition to your organization. Questions can be something that is very tricky, and there are certain things we need to be cautious about when we're asking questions, and there are certain things we can't ask questions about, things about nationality, religion, age, marital status, family status, gender, health, and physical abilities. So a question that I think gets asked a lot, and it's not necessarily meant to do harm, but is trying to get to know who that person is you might ask, do you have children? And that's a question that we shouldn't be asking in the interview process. But it may be something that you're concerned about because that whatever the restrictions are or the needed, what you need the person to do, you may need to know that they're flexible. And so that may be a concern that you have. So a question that you might ask is, this position can require overtime or travel on fairly short notice. Is that something that you would be able to do? And you get that same question answered without asking any of these questions that we should be avoiding. Something else is talking about physical abilities. So maybe you need them to be able to lift so many pounds. They need to be able to lift 10 pounds on a regular basis. And you want to be sure that that's something that they are comfortable doing. So if you have a good job description, you've laid out what their physical requirements are, make sure they have an opportunity to read the job description, and then you can ask the question that as you've looked at this job description and you've seen what the physical abilities are, can you meet the requirements with or without reasonable accommodations? And ask that question that way. Every so often, we do have to separate for whatever reasons. So when you're making a decision to separate, you want to review all of the facts. We also want to be sure that we're not doing it out of haste and out of emotions. Sometimes an employee may do something and it's something that you really disagreed with, and the quick answer is they're out of here, they're gone. So take that moment and look at the facts. Is this something that we need to separate, or is this something that we need to talk about how we would handle it differently another point in time? Review your process. So your process may be that it's yourself and the employee having this conversation. Your process may be that it's yourself, the employee, and another member of your team that is also in this process. Make sure you're consistent with your process. And then finally, be as respectful as possible. So maybe there's some key metrics that this person is needing to meet, and they're consistently not meeting their metrics. And maybe there's also a few other things out on that fringe. We don't need to bring the kitchen soup or kitchen sink and tie everything in together about why this is not working out. Those metrics are not being met, and if that's ultimately the reason why it's time to separate, let's focus on that. We don't need to fill dead space and try to make everybody feel great at the end of it, but we also need to be respectful in this process and stick to the facts. So final thoughts are use resources that are available to support your organization. I talked about the National SHRM chapter. There's also local chapters. So the South King County chapter meets in Kent the third Thursday of every month, and there's a different topic with a different expert every time, and they are very helpful and very useful, and it's something that I take members of my team and we go to on a regular basis also. Don't rush to hire, and be consistent. Thank you.
Sarah, thank you very much. That was great. Do we have any questions from the audience? We have one right over here.
When you are hiring someone, is it acceptable or legal to do like a trial period before you fully commit to hiring them? Can you do that?
So sometimes we have needs that we're unsure if it's going to be a long-term need. And so in that situation, we will hire somebody, maybe temp, to start with and talk about that we know we have an immediate need right now, but we're not quite sure how long. So we let someone know that we're expecting to need your services for, say, 60 days. And as we approach that end of that 60 days, we'll talk about whether or not we have ongoing need.
Here's something I'd like to add to that, too, is sometimes an employer will want a prospective employee to demonstrate their skill at the job site, and they'll say, this is a real case that I had. It was a dog washing business, and they said, let me see how good you are at grooming this dog. Go ahead and groom this customer's dog. And they did it, and they said, okay, that's good, you're hired. Well, even during that demonstration of a customer's dog, that's considered employment. You'd have to pay them at least minimum wage. They get hurt, they get bit by the dog, it's a workers' comp claim. If you were to remove them from the job site and had a mock setup, let's say a mock telephone call to see how their telephone skills are, and there's no promise of employment, that's different than if you on the job during company hours doing company business. So just bear that in mind too.
You mentioned SHRM. Is that, and then what was the other one that has a fee?
Well, the National SHRM chapter has an annual membership fee. It's about $180 if you wish to join, and it's a great inexpensive resource. There's also local chapters of SHRM that meet monthly, and it's a nice opportunity to meet others who may have some of the same struggles and challenges, or other HR professionals that you can talk to and hear what some of their companies are doing. But every month there's a different topic. So this next topic will be on healthcare insurance and some different strategies that you can use to manage your healthcare costs. And they rotate, so you can hear 12 different topics in a year, and it's about $25 per session. It's lunch, so you get lunch and hear about a topic. So.
Great. I think that what's come across from all of our speakers so far today is that there are great resources right here locally. And I'm sure one question to ask, I think probably all of you, if a small business was not to the point of, say, 15 employees, they've got just a few and they need some little bit of part-time help to come in and help maybe get the correct HR records system set up or whatever. Are there consultants out there that will hire on to come in on a contract basis to help the temporary needs?
There are a lot of individuals that are contractors in HR, and there are even organizations like Archbright that they specifically have contractors on staff. And so whether it be that you're looking for someone to come in on a regular basis or, just a single visit, they have those available.
Good, good. John, one of the things that you touched on was background checks. What if a small employer is in need of doing a background check on a possible employee? Is that something that could be done through your office to help develop the form to have a prospective employee sign to give authorization to have a background check run? And is that something that a company's attorney could handle for them on a small basis?
Yes, but cost effective would be to hire one of those, like there's a guy with a 425 number I can get you that has his email at TalentWise, and he'll do it pretty cheap for, you're trying to hire talent, so his website is pretty creative. Lawyers have a lot of tools. We can look up court cases and criminal records, and actually the public can do that. But yeah, there's a form that you can have where here's what you can check and here's what you probably shouldn't check. The question about Facebook is always, there's some Facebook firing and hiring cases that I don't even understand, but I know they're out there.
Okay.
Yeah.
Okay, good. Any other questions at all? We have one more question from the audience here.
Does that cover an employer if you have concerns with an employee and they have expunged records? Can you still be protected by, if you come across a person, their records are closed or sealed for whatever you're concerned about, can you still have the right to not hire them?
Just like a juvenile record or something that's been expunged?
More of criminal or DUIs or something.
That's a good question.
Yeah, I mean, there's a couple of ways to handle it. I mean, on your employment application form, I mean, you can ask questions like, do you have a felony record or something like that, right? Or committed a felony. And if they lie about that and you do the background check, then obviously you don't have to hire them. But with things like expungements, I mean, those won't necessarily show up because they're either sealed or they're totally gone. And so those won't show up on a background check, for example. And so you won't have that knowledge. And so if that employee does something that is similar to what they did in the past, for example, you wouldn't be liable for that particular negligence for hiring them because you didn't have knowledge that they had a history, for example. Does that make sense?
To add to that, I have a concern if someone comes in and they tell the truth about a criminal offense, and then you start thinking about private versus public, like, no one's going to hire a potential school teacher if they have a criminal charge of some nature. We're private, so I don't know about public government, but there are applications, and we get calls all the time from former teachers that were in trouble and only investigated, and the question is always very important, like, have you been charged with a crime? I don't think people have to answer that. It's more, have you been convicted of a crime? I saw one application that says, have you been investigated for any conduct relating to abuse or neglect of a child? And it's like, Well, just because someone was investigated doesn't mean they did it. So there's some tough calls there. Yeah.
I think what we always want to take into consideration is exactly what a lot of these topics with our experts have brought to light. I think it proves that as a small business, you need to think through every step of the process, because you can put a lot of years into work building a company, and it can be taken down very quickly if you're not protected properly, or hire or get the counsel of people around you that you can have access to. One of the things that this series of workshops has tried to do is to just bring to light a lot of these issues, bring local folks and the local experts to the table and answer these, but you know how to get those resources. And one of the things that we will always do through our Office of Business Development is, if you have a need for an expert in HR or an attorney or something like this, that we're here to help get you referrals, get you lined up and in touch with the right person that you can sit down face-to-face and get that type of counsel and that kind of expertise quickly and efficiently and hopefully cost-effectively for your company. I think we have one more question in the back of the room.
This question is for Sarah. When you keep records, do you have to keep the physical record, or can you not scan it and keep an electronic file so you don't have the logistics of boxes of paper?
You can scan, and we do have some of our records scanned, but some of them, the logistics of scanning is, it's easier to find a spot to store them. So you have to kind of balance that. And also how much, how secure is your scanned records versus finding a secure place for those storage boxes, and how much time do you expect that you're going to need to go back to those records? Because especially when someone initially leaves your organization, there may be more references or a variety of things. Maybe they apply for a mortgage and you get requested for verification of previous income. And so how much are you going to need to be in those records? And so kind of balancing that aspect of it.
At this time, I'd like to thank the Auburn City Council and Mayor Nancy Backus for the continued support and funding so we can continue this type of programming for our local businesses, and also our couple of partnerships that we have consistently with the Auburn Area Chamber of Commerce, the Auburn Downtown Association, and spreading the word on these available workshops and expertise. And at this point, I would like to thank our panelists, and thank you very much.